You don't have to go all the way to the end.
Sorry.
Oh, any way you want.
I don't know if this is.
I don't want you to get pressure in both hands.
You know my lawyer? Ah, he's in the judge.
So
This is,
I can just leave that on, right?
yeah.
You don't want to do that.
Yeah,
Okay.
I know him very well. I know him very well. Is this the biggest one? It's just the biggest one. Yeah. It's like the brain stuff. Well,
Yeah.
the feeling of everything's like,
Oh, I figured.
Right. So, well, because there was an issue, they had the gun stuff in his weapons and this building. And so that gun's going to be consecutive every other time. So we got so we had to redo the scope for him. So we got to go what they wanted to do. Correct. But I had that taken off. This is. Let me say it is working. There you go. Oh, here? Yeah. Didn't you go? Yeah. So, yeah. So this is what we went through already. We did all this already. There's a change here. Of course, consecutive and aggregate 2 years of 9 plus 9 years. That's 2 years on the felony assault plus the 9 years on the weapon. 2 years on the weapons and disability. So, yeah.
I thought it was
No, the sentence could be 9, 12, 18, 24, 30, or 36. So if the minimum sentence, let me say, I'm going to give you the minimum of everything. It's 2 years on the felony assault, 9 months on the weapon and disability.
okay.
So, but if in fact you want to go with consecutive, then it's 12 years on the, which was 8 plus the 4 for the Liberty Toad, plus 36 months. All right, so that's that correction. If he was unpursued control, community defense, which included the judge determining or closer control, sentencing consecutive term, minimum 1 year up to the balance of the remaining police control, which is 973 days. You can forfeit all of that, be subject to restitution. There's nothing there. You may be subject to the prosecution. And this is, you'll have up to 18 months, 3 years of post-return leave credit GPS device. This was compared to return to prison, but they have another 9 months for each violation for total 50% of the prison term plus any mandatory time. Non-specifications. Minors week for Jewish groups not include any mandatory terms such as the required by certain offenses and specifications. In a non-mandatory term, by granting community control, I will have conditions to follow. If I violate those conditions, I can be returned to court with greater restriction prison term. I am a U.S. citizen. I'm not a U.S. citizen. That doesn't apply. I do face mandatory time in prison. If I go to prison, God does allow me to apply for judicial release after specific time. I discussed this written clearly with my attorney and I've answered all my questions. So here, this is really the reading. So this is the felony assault. It's a second degree felony, there's no mandatory time. There's a presumption of prison, the range is 2 to 8 years. It's a qualifying for the RDO. It's qualifying, for the Raven folks. That's 1 to 4 years, of 2 to 8, that's 50%. There's no mandatory fine, it can be up to $15,000. The firearms effect is 3 years. And the RVO is 1 to 10. But it's court may impose the maximum imposed count 2 if RVO time is imposed, the time is mandatory. So, and then the representative disability is 9, 12, 18, 24, and 30, 36 months. So that's how they come up with this. 24 years, potentially up to 28 years. They're asking for 14. We're asking for 14. 14. Okay.
Let's try 14.
14 to 18. Remember? Right. Right. My turn. And I'm just going to say that you should adopt this because there was an injury in the victim, but yes, but it's no discretion. That's what it's an issue for them. It's 14, 14. Only such a presented to you is case on the possible documentation. You will agree to 14. You should go on. All right. Unless you have you're good. All right. Yeah. What? Do I need to say that? No. You can just you can just that's not really stuff. I'm so sorry. I'm sorry. This is a substantial lesson. I'm sorry. Yeah.
She's back there shaking her feet with the feet.
What is it?
If we can, that's going to take off.
Yeah.
Correct. You're going to be able to get that moving. Just got to know.
Yeah. How would I want me to send it from the library? I still don't have 100 calls.
All rise. Court of Common Pleas is now in session. The Honorable Eugene Lucci presiding.
May be seated. We're on record. This is case number 22 CR 000536, State of Ohio versus Darnell L. Burns. Mr. Burns is in court, represented by counsel. Attorney Timothy Kuharski, representing the State of Ohio, is Assistant Prosecuting Attorney Lisa Naroda. Mr. Burns, you are charged in a 3-count indictment filed by the Lake County Grand Jury on August 15th of 2022. Count 1 is attempted murder, a felony of the first degree with a 3-year firearm specification and a repeat violent offender specification. Count 2 is felonious assault, a felony of the second degree with the same 2 specifications, 3-year firearm and repeat violent offender specification attached to it. And count 3, having weapons while under disability, felony 3 with a 3-year firearm specification attached to it. And the first 2 counts, the attempted murder and the felonious assault, are Senate Bill 201 qualifying offenses for an indefinite prison term,
meaning that there's a tail of half of the term I give you on those. And further, the firearm specification on count 3 is incorrect. That should not be on there. So it's my understanding you have entered into an agreement with the state of Ohio whereby the state would find acceptable and you would be willing to provide your plea of guilty to count 2, felonious assault, felony 2, the firearm specification attached to it, the repeat violent offender specification attached to it, and count 3, having weapons while under disability. And that means that count 1, attempted murder, felony 1, would be dismissed, and the firearm specification to count 3 would be removed. It's further my understanding that you have an agreed sentence here to recommend to the court for a total of 14 years to 18 years, which would include the specification time. Is that your understanding as to what you want to do here today?
Yes, Your Honor.
And you understand I'm not bound by the agreement.
Yes, Your Honor.
But if I do go along with it, then it is an agreed sentence and you can't appeal.
Yes, Your Honor.
You understand that?
Yes, Your Honor.
Okay. And I need for you to speak up so that the recorder can properly pick up your voice. So before I can accept your plea of guilty to these 2 charges and the 2 specifications attached, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are changing your plea to guilty of your own free will. How old are you?
33.
And how far did you go in school?
12th grade.
And do you have the ability to read, write, and understand the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No, Your Honor.
Have you taken any within the last 48 hours?
No, Your Honor.
Have you ever been medicated, hospitalized, or treated for any mental illness in your life?
No, Your Honor.
Have you received a copy of the indictment?
Yes, Your Honor.
Did you read the charges?
Yes, Your Honor.
And you just say yes or no is fine. Do you understand the charges?
Yes.
Did you discuss those charges with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the charges?
Yes.
Do you agree that counts 2, felonious assault, and count 3, having weapons while under disability, describe what you did here?
Yes.
And do you wish to plead guilty to those 2 charges and the firearm spec and the repeat violent offender spec attached to count 2?
Yes, Your Honor.
I've been handed a 6-page document called Written Plea of Guilty, and you have a copy in front of you. And I went over this extensively with your attorney and the prosecutor in chambers, and that's the delay for coming here into the courtroom, to make sure that it is as accurate as we can get it. And it's my understanding that Mr. Kuharski had time to go over our latest revision with you, correct?
Yes.
And did you read this document?
Yes.
Do you understand it?
Yes.
Did you discuss this document with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the document?
Yes.
Do you agree with what it says?
Yes.
And do you wish to sign it?
Yes.
I'm going to go over the charges you are proposing to plead guilty to so that we are all on the same page. Count 2 says that on May 20th of 2022, in the village of Fairport Harbor in Lake County, Ohio, you knowingly caused or attempted to cause physical harm to Jessica L. Brothers or Jessica L. Brothers unborn. She's not pregnant, right? Okay, you're just mimicking the statute. Okay. So you couldn't knowingly cause or attempted to cause physical harm to Jessica L. Brothers by means of a deadly weapon, namely a firearm. That's called felonious assault. It's a felony of the second degree. It's in violation of Revised Code Section 2903.11A2. Do you understand that charge?
Yes.
And is that the first charge you wish to plead guilty to in this case?
Yeah.
Attached to it is a firearm specification that says that during the offense you had a firearm on or about your person or under your control, and you displayed it or brandished it or indicated you possessed it or you used it to facilitate the offense. Do you understand that?
Yes.
And do you wish to plead guilty to that?
Yes.
A second specification says that you are a repeat violent offender, having been convicted of complicity to aggravated robbery and complicity to felonious assault in the Lake County Court of Common Pleas, case number 08CR000094 on May 8th of 2008. Do you understand that specification?
Yes, Your Honor.
And you wish to plead guilty to that?
Yes.
Count 3 says that on May 20th, 2022, in the village of Fairport Harbor, Lake County, Ohio, you not having been relieved from disability under operation of law or legal process, knowingly acquired, had, carried, or used a firearm, and you were under indictment for or you had been convicted of a felony offense of violence, namely that complicity to aggravated robbery and complicity to felonious assault, Lake County Court of Common Pleas, case 08CR000094 on May 8th, 2008. That's called having weapons while under disability. It's a felony of the third degree. It's in violation of Revised Code 2923.13A2. And do you understand that charge?
Yes.
And is that the second and final charge to which you wish to plead guilty in this case?
Yes.
You understand if you plead guilty to the charges, you are admitting you committed the crimes.
Yes.
You understand if you had any defenses to the charges, you give up those defenses by pleading guilty.
Yes.
You understand by pleading guilty, you are giving the court the power to sentence you immediately, and I will, because that's your agreement that I do that.
Yes.
And the case has been set for a jury trial today, and I don't know if anything was filed in contemplation of trial, but if something was filed, just to clean up the file, I'll just summarily deny any pending motions because you're pleading guilty now, and once I accept your plea, the only thing left to do would be sentencing, which would occur immediately after I accept the plea. You understand that?
Yes.
And you understand any rulings previously made by this or any other court on this case prior to this moment would not be appealable because you're pleading guilty at this time.
Yes.
And you understand that any claim of ineffective assistance of counsel, meaning that your attorney did not perform as a reasonably competent attorney, cannot be made on the basis of your attorney's services or performance rendered before today.
Yes.
And you understand that the two charges to which you are pleading guilty are separate offenses. They stand on their own, meaning they do not merge, meaning you can plead guilty to both. I can accept that plea, find you guilty, and give you a sentence on both and make those sentences consecutive.
Yes.
You have certain trial rights. You're giving them all up by pleading guilty. Oh, by the way, I think I misspoke. Although the schedule I have in front of me says the trial is to be today, it's actually supposed to be 2 days from today. It got moved.
I think it was the 14th, Your Honor.
Isn't that 2 days from today?
No, today's the 1st.
Okay. Oh, or 2 days from yesterday.
2 weeks from now.
2 weeks from yesterday.
Correct, Your Honor.
Right. Okay. Sorry. Yeah, but it was originally scheduled for today.
Correct.
And then it got moved to 2 weeks from yesterday. All right. So you have certain trial rights. You're giving them all up by pleading guilty. I'm going to explain them to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights. As I explain your rights to you, if you have any question about what I'm saying or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Yes.
You don't have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. The trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove your guilt beyond a reasonable doubt. Do you understand that?
Yes.
You understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal.
Yes.
You understand that with a jury trial, the jury makes the decision. I don't. Whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. Do you understand that?
Yes.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of a particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. Do you understand that?
Yes.
You have the right to tell your side of what occurred here and testify in your own defense. Or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty of something, hide, maybe have a prior conviction. The jurors would be told you have that constitutional right not to take the stand and testify. We would select only individuals to serve as jurors in your case who answer under oath during jury selection that they will uphold that right. Do you understand all of that?
Yes.
Do you understand that if you were not pleading guilty today, you would always be represented throughout this case by an attorney at law, free of charge to you, paid for by the taxpayers if you could not afford counsel?
Yes.
You understand that if you were not pleading guilty today, you could appeal the many decisions I would make throughout the case. You could appeal the jury's verdict. You would have a transcript typed up of everything that was said or done in this court so you can demonstrate to a higher court any mistakes made here to get those mistakes corrected, and an attorney to handle that appeal for you. And if you could not afford that, all of that would be provided to you free of charge, paid for by the taxpayers. Do you understand that?
Yes.
You understand a plea of guilty is a complete admission of guilt.
Yes.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to count 2, felonious assault, felony 2, the firearm specification attached to it, the RVO, the repeat violent offender specification attached to it, and count 3, having weapons while under disability, felony 3?
Yes.
Now, it's my understanding, based upon my discussion with counsel in chambers and in going over the form, you were on PRC, post-release control, from the prior time I sent you to prison when you committed this offense.
Yes.
And it's my understanding that I sent you to prison, was it the two complicities? The complicity to aggravated robbery and complicity to felonious assault?
Yes,
All right, so I sent you to prison May 8th of 2008. How much time did I give you?
12 years.
12 years? And so, how much PRC time was imposed originally?
I think it was 5 years.
5 years?
Yes.
Okay, and so based upon a letter from the Ohio Adult Parole Authority that your attorney gave me in chambers, it shows that you have 973 days remaining on PRC. You understand that, correct?
Yes.
And have you been to prison any other time other than the time that I sent you?
No.
So do you understand that by pleading guilty, you are voluntarily giving up your liberty for whatever length of time I sentence you to prison?
Yes.
And you understand I have to send you to prison.
Yes.
And so, in addition to the underlying offenses, the felonious assault and the weapons under disability, you're pleading guilty to two other specifications, a gun specification and a repeat violent offender specification. You understand that?
Yes.
And you understand that the gun specification is a 3-year mandatory gun specification, so that I have to sentence you to 3 years on that firearm specification. You understand that?
Yes.
And that time would be served prior to and consecutive with any time I give you on the felonious assault and the weapons under disability.
Yes.
You understand that you are pleading guilty to a felony of the second degree, the felonious assault, and by pleading guilty to the repeat violent offender specification attached to that count, you would face additional or mandatory prison time. You understand that?
Yes.
And you understand that if I give you the maximum on the felonious assault, then I can give you between 1 and 10 years, a whole number of years, on the repeat violent offender specification attached to that felonious assault.
Yes.
And you understand that the repeat violent offender time that I give you would be served prior to and consecutive with the underlying prison term on the felonious assault and the weapons under disability.
Yes.
And so you understand that also I can terminate your post-release control and impose the 973 days that remains left on your PRC time from the prior conviction.
Yes.
And that would be served prior to and consecutive with any time on this case.
Yes.
So you understand the order of things. If I gave you the PRC time, and if I gave you RVO time, the order would be the PRC time gets served first, the 973 days. Then the 3-year firearm specification gets served next. Then the RVO time, anywhere between 1 and 10 years, whatever I pick, gets served. Then the time on the felonious assault and the weapons under disability. So you understand that's the order.
Yes.
And so when we are talking about the time that you can get on the felonious assault and the weapons under disability, we're not including the time for PRC, the 3-year gun spec, and the RVO time. We're putting that aside when we're talking about just the sentence for the 2 underlying crimes.
Yes.
And I don't mean to make this complicated, but this is the way they wrote the law, and I've got to give it to you the way they wrote it. You understand that?
Yes.
And I'm sure you and your attorney have talked about that, because I know I've talked to your attorney about that, and I know that he has gone over this with you. So, on the felonious assault, because it's a felony of the 2nd degree, it's a qualifying offense, and I have to give you an indefinite sentence on that. You understand that?
Yes.
And what that means is I give you a minimum sentence, and the law derives from that minimum sentence what the maximum sentence would be. And so the minimum term that is attributable to felonious assault, felony 2, would be between 2 and 8 years, a whole number of years. So that means for the felonious assault, I pick a number, 2, 3, 4, 5, 6, 7, or 8 years, and the maximum term is 1/2 of that. So if I pick 8 years, which would be your joint recommendation, then half of 8 is 4, you add the 4 to the 8 is 12 years. So the indefinite sentence on the felonious would be 8 to 12 years. You understand that?
Yes.
And we'll talk about how the state accesses that tail of 4 years. I'll call it a tail, but that indefinite part of 4 years, because that's really within your control. And we'll talk about that, and you need to know that right from the very beginning. And you understand that on the weapons under disability, the minimum prison is 9 months, the maximum prison is 36 months, and it has to be either 9, 12, 18, 24, 30, or 36 months. You understand that?
Yes.
And on the felonious, the possible fine could be $15,000, and on the weapons under disability, the possible fine can be $10,000. The fine is not mandatory. You understand that?
Yes.
And you understand that I can make the sentences consecutive on these 2 underlying charges, consecutive with each other, and you understand what consecutive means, correct?
Yes.
And so if I made them consecutive with one another, then the longest minimum term would be the 8 years plus 36 months. And it's easier to say 3 years, but the law puts the F3 in terms of months, so I have to make it more complicated and say 8 years plus 36 months. So you understand that would be the longest minimum term, 11 years, and the longest maximum term, you would add the 4 years from the 8 to it, and it would be 15 years. So it would be 8 plus 3, 11 plus 4 is 15 years. Just converting the months to years. You understand that?
Yes.
All right. So then, if you were to add in the spec time of 3 years and not saying I'm doing this, but add the maximum on the RVO time of 10 years, you would add 13 years to the 15 years, which is the longest maximum term, and that would be 28 years. So excluding any PRC violation time, the maximum you can do if everything goes wrong, meaning if you screw up in prison and I give you the maximum, so wrong for you, it would be 28 years. You understand that?
Yes.
And the maximum fine, if I made them consecutive, would be $25,000. You understand that?
Yes.
Now, you understand your agreement with the state calls for me giving you the maximum on the felonious, which would be 8 to 12, including that 4-year tail, plus 3 on the firearm specification, plus 2 on the RVO specification, plus 12 months or 1 year on the weapons under disability. You understand that?
Yes.
And so you understand if I add the 8, 3, 2, and 1, that comes up to 14. You put the 4-year tail, so it's 14 to 18 years. So your agreement, as I mentioned earlier, is to jointly suggest to the court that I sentence you to the minimum aggregate of 14 years and the maximum aggregate of 18 years. Is that your understanding as to what you want to do here today?
Yes.
And that 14 to 18 does include the specifications, but it does not include any PRC violation time. You understand that?
Yes.
Now, has the Department of Rehabilitation or the Ohio Adult Parole Authority taken any action against you for the PRC violation? Did they sanction you? No, they haven't. So you understand that if I don't sanction you for that, they can
Yes.
sanction you for that.
Yes.
And what they can do is they can actually well, this is within their regulations, but they may be able to add 9 months on to your sentence, and you would serve that prior to and consecutive with anything I give you on this case.
Yes, I understand.
Now, upon your release from prison, no matter when the release is, whether it's at the minimum, and I'll talk about that in a second, or at the maximum, you would be on a mandatory period of post-release control for a minimum of 18 months up to a maximum of 3 years. You understand that?
Yes.
And if the Adult Parole Authority wants to, they can just put the PRC time from before, what's left, and tack it on to the end, and it would be whatever's longer. What was imposed on the prior prison that I gave you, or what gets imposed here, whichever one lasts longer, that's the one that controls. So there's a minimum of 18 months here, and if they determine 18 months would be the PRC time, the 973 days left on the previous one comes out to more than 18 months. Comes out to closer to 3 years. And so they could just put that, tack that on the end of this case. And that would be the PRC time for this. You understand that?
Yes.
But they can go up to 3 years on this case. You understand that they can require you to wear a GPS device while on PRC.
Yes.
And you understand that they can return you to prison for up to 9 months for each violation of their rules. And they can do that multiple times, up to 50% of the original prison term I give you for all of the PRC violations together. You understand that?
Yes.
And you understand that if you're convicted of a new felony while on PRC, like convicted of this one on the previous PRC, in addition to being punished on the new offense, the sentencing judge could terminate your PRC and impose a consecutive prison term of a minimum of 1 year or what time remains on the post-release control term, whichever is greater. You understand that?
Yes.
Now, as far as your release date goes, disregarding good time credit, you are expected to be released when you finish the minimum aggregate term that I give you, unless the DRC, the Department of Rehabilitation and Correction, determines that you must remain in prison for bad conduct. So that's what I mean. You sort of like hold the keys to your freedom after the minimum term, or whether you're released at the minimum term, because it's all geared towards your conduct while in prison. So, in other words, your expected but not guaranteed release date from prison is at the end of the aggregate minimum term that I give you. So, not including the tail, the actual term I give you, after serving any mandatory prison for the specifications and or any PRC violation time, and less any jail time credit or any earned minimum prison term credit. You understand that?
Yes, sir.
And so I say it's the expectation because the Department of Rehabilitation and Correction could overcome that expectation if they hold a hearing within the walls of the prison and they make specified determinations regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. So I'm going to get specific here, just so you know, prior to pleading guilty, what the criteria is. And your previous term didn't have this because this was only made the law in 2019. So specifically, your presumptive or expected release date from prison is at the end of the aggregate minimum term I give you after serving the mandatory time, less any jail time credit. The presumptive release date is rebuttable, and if you commit institutional rule infractions that compromise prison security or threaten the safety of prison staff or inmates, or you commit a violation of law that was not prosecuted, and the infractions or violations show that you have not been rehabilitated, or by your conduct you show you continue to pose a threat to society, or if you've been placed by the DRC in extended restrictive housing at any time within the year preceding the date of your release hearing, or if you are classified by DRC as a security level 3, 4, or 5, or at a higher security level, then your release date would be up to the aggregate maximum term. So you understand, I'm not involved at all. The court's not involved in that decision. That's all done by the prison within the prison. And if the department at that hearing makes the specified determinations and rebuts the presumption of your release date at the end of the aggregate minimum term, they may maintain your incarceration after that minimum term for the length of time they determine to be reasonable, subject to the limitation that they have to let you go at the end of that tail, that 4-year tail. So you understand that if you're not released when the minimum term ends, you'll serve additional specified periods of time given a new release date. And then you'll be released on that date unless they again deny you release for the same reasons that I had mentioned just earlier. And they can do that multiple times, but when you finish the maximum term, they do have to release you no matter what. You understand that?
Yes.
Now, there are two types of credit, and none of this credit applies to PRC violation time, gun spec, or the RVO spec, because that's all, if it's imposed, it's all mandatory time. So the two types of credits are the 8% credit and the 5 to 15% credit. Now, I don't know whether either of these credits are applicable to the felonious assault. They probably are applicable to the weapons under disability because that's not mandatory time, it's not a sex crime, and it's not a crime of violence. So these credits, or the 8% credit, would likely be applicable to the weapons under disability. The question is whether the 8% credit and the 5 to 15% credit are applicable to the felonious assault, because it is a crime of violence, and I don't think that they are applicable, but it wouldn't be the first time I've seen the DRC do something that I didn't think was the law. So I'm going to explain it to you anyway. So the 8% credit is earned by the prison offering you educational, vocational, or rehabilitational programming for that purpose of obtaining the 8% credit. It's 8% of time to be served or a certain number of days according to the regulations. And there's no guarantee that they'd offer it to you or that you would earn it, but now you know about it. Then there is the 5 to 15% credit that only applies to the felony 2 charge, and you might be able to earn some of that credit because it's not a sex offense and it's not mandatory time. The question is whether they allow it on a crime of violence. And so that credit is awarded for exceptional conduct or adjustment to incarceration as the basis for awarding that reduction. So the way they have this set up is they punish you by adding time on within my sentence for bad conduct beyond the minimum, and they can take time off for good conduct or exceptional adjustment to incarceration, and that has to involve the court, and the prison has to ask the court for it, and the court has the right to deny it, but the court would not deny it without having a hearing. And so it's not this is called the 5 to 15% earned reduction of minimum prison term credit. It's not guaranteed. The department might not request it. The court might not grant it. If they do request it, the court is expected to grant it, but the court can still deny it upon proof rebutting the presumption that the court should grant it. Now, I haven't seen any regulations for courts, so I don't know what exceptional conduct is or adjustment to incarceration. I would think that that's the normal rule, that people should behave themselves in prison and adjust to the incarceration. So I don't know if any court's ever granted this yet because the statute's only 3 years old and I haven't seen anything come out yet on the regulations. You should also know that the issue of Senate Bill 201 time is pending in the Supreme Court, and I'll recognize an objection to it because that could change the law that I'm giving you right now on this, because the Supreme Court is going to end up deciding whether it's an unconstitutional law. And if it's unconstitutional, then all they would do is just take off that tail. Not that I'm thinking of judicial release, but I'm telling you that judicial release is tied to the aggregate minimum term, not the tail. So, you know, you have to wait a certain period of time before you can file for judicial release. Like all of the spec time, PRC violation time has to be served first before the clock starts running, and you can ask for a judicial release. In this case, it might be 5 years into the actual term before you would be eligible to ask, but it's tied to the minimum term I give you, not the maximum term. You understand that under Ohio and federal law, you're disqualified from purchasing, owning, possessing, or using firearms or ammunition for firearms. That's the weapons under disability charge. You understand that?
Yes.
You understand that you cannot vote from prison. In order to regain your ability to vote, you'd have to re-register upon your release from prison. You understand that?
Yes.
You understand that you cannot serve as a juror while in prison, and certainly while on post-release control in any case where the state of Ohio would be a party, because you would still have an active case with the state of Ohio on the other side. You understand that?
Yes.
And you understand you cannot hold any position of public honor or trust.
Yes.
Understand you're pleading guilty to a crime that could form the basis of a civil lawsuit against you by anyone suffering any damage or harm as a result of your criminal activity. I'm assuming that none of the shots hit.
The shots did not strike Jessica Brothers. They struck the B-pillar of the car on the driver's side. She did have damage to her vehicle. I don't know the amount she said that it hurt.
Okay, so you understand that your plea of guilty could form the basis of a civil lawsuit for any damage, could include psychological damage also, but you understand that if there is a civil lawsuit that arises out of your conduct here, they don't have to prove what you're pleading guilty to in a civil court proceeding. They would just, the court there would just take it, okay, yeah, you pled guilty to felonious assault.
Yes.
You understand that? You understand that there would be a drastic increase in penalties if you have a subsequent similar violation, meaning these are two violent offenses now, the previous one and this one, so that if you are charged with another F2 or F1, the RVO time will be mandatory and not discretionary with the court. You understand that?
Yes.
In addition to the potential fines that I mentioned, I will order you to reimburse the government the cost of confinement, supervision, any treatment, and court costs. You understand that? And the cost of confinement also includes transportation costs between the court, the jail, and the prison. Do you understand that?
Yes.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
You understand a failure to pay all fines and costs in full can result in the state blocking your license plates until they are paid in full.
Yes.
You understand all the potential penalties?
Yes.
Any question at all as to what can happen to you as a result of your plea of guilty today?
No, Your Honor.
And counsel, did I forget any advisements?
The state has nothing to answer for.
I don't believe so, Your Honor, no.
You understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing.
Yes.
And you understand when it does come time for sentencing, I'm not bound by and do not have to follow that joint recommendation of 14 to 18 years.
Yes.
So you understand this could turn out that you do 24 to 28 years.
Yes.
Do you still wish to plead guilty?
Yes, Your Honor.
Pardon?
Yes, Your Honor.
Has anyone else made any kind of promises or threats to you in order to get you to plead guilty?
No.
Are you entering this plea freely and voluntarily?
Yes.
Have you told your attorney everything you considered important in this case?
Yes.
Did you hold back anything from him?
No.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes.
Although this may be your attorney's recommendation for you to plead guilty in the fashion in which you are doing, is this your own decision and voluntary act to enter this plea of guilty?
Yes.
Has your attorney done everything you've asked him to do for you in this case?
Yes.
And are you completely satisfied with the legal representation provided by Timothy Kuharski, your attorney?
Yes.
And Ms. Naroda, what is the basis for the recommendation, and what would the facts show if the case went to trial?
Judge, had the case proceeded to trial, the state would have brought forth the following facts that the state field demonstrate what the defendant did on May 20th of 2022, and that is the basis of the recommendation for the two charges that he's pleading to. And those facts were these, Judge. On May 19th of 2022, Painesville Police Department responded to a disturbance in Kentucky Fried Chicken in Painesville. It was between the defendant and Jessica Brothers, the victim in this case. I believe that argument and that dynamic between Ms. Brothers and the defendant continued into May 20th of 2022, such that when she returned to her home at somewhere between 2:30 and 3 o'clock in the afternoon at 313 7th Street, Fairport Harbor, she pulled into the driveway. She attempted to accomplish a three-point turn so that she could pull out. However, the defendant pulled in after her. It's the state's understanding of what happened next, based on what Ms. Brothers reported on May 20th of 2022, is the defendant got out of his car. He was possessing a gun, a small black handgun. The defendant brandished the gun at the driver's side of the vehicle, and struck the window, fired the gun, causing the B-pillar to be struck on the driver's side while Ms. Brothers was seated in the driver's seat. The car was running. The projectile or the bullet splintered off and struck or punctured the pool, which was behind the house. The victim, Jessica Brothers, drove away immediately 11 seconds after the shot was fired. She went to 6th Street and called 911 and explained what had happened. She subsequently explained it to the Painesville Police Department and the Fairport Harbor officers who arrived to the area where she was standing. She said who did this. She said what happened. She said what she discovered about her car. She also went back to the scene and explained where she had attempted to turn the car around. While she was at the scene with officers, the defendant called her phone, and that conversation was heard, or that comment was heard by Fairport officers and recognized as the defendant. He said, "This is going to get serious." He was gone. The evidence collected at the scene, consisting of glass particles and split projectiles, reported to Lake County Crime Lab. The projectiles found in the B pillar and that of the swimming pool were determined to be bullet that had split, and the glass that was collected from the scene and that of Ms. Brothers' vehicle was matched to glass found in the cowl of the vehicle that the defendant was alleged to have been operating that day, a Honda Civic owned by Tamar Badley, and that glass was determined by the Lake County Crime Lab to match that of the victim's vehicle.
Mr. Burns, did you hear and understand everything the prosecutor just said?
Yes, Your Honor.
And is everything she said true?
Is it true? Not true. It's not true. Yes, Your Honor.
What is your plea to count 2, felonious assault, a felony of the 2nd degree, a Senate Bill 201 qualifying offense?
Guilty, Your Honor.
Your plea to the 3-year firearm specification attached to count 2?
Yes, Your Honor.
Guilty?
Guilty.
Your plea to the repeat violent offender specification attached to count 2?
Guilty, Your Honor.
And your plea to count 3, having weapons while under disability, felony 3?
Guilty, Your Honor.
I'm going to hand you the written plea of guilty, the 6-page document we talked about earlier. Make sure you've read it, make sure you understand what it says, make sure you agree with what it says, and if you sign it only because that's what you want to do. I've not made any changes since you last saw it.
This one? Oh, yeah, it's the same one. This is just the one that you... Grab it first. Yeah.
For the record, Judge, I'm handing you the written plea of guilty. It has been signed by the defendant in presence of his counsel, Mr. Murphy, and also it is by myself on behalf of the state of Ohio.
I will sign the judgment entry at the end of the document and the sentencing computation sheet, and I will make the document part of the record in the case. The record should reflect that defendant Darnell L. Burns was here with attorney Timothy Kuharski in open court. I informed Mr. Burns of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charges, the effect of the pleas, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his pleas and find him guilty of count 2, felonious assault, felony 2, Senate Bill 201 qualifying offense in violation of Revised Code Section 2903.11A2. The 3-year firearm specification attached to that count, the repeat violent offender specification attached to that count, and count 3, having weapons while under disability, felony 3, in violation of Revised Code Section 2923.13A2. Count 1, the attempted murder, will be dismissed upon completion of sentencing. The parties have waived any further pre-sentence investigation, because the court does have familiarity with the defendant, having sentenced him on the prior felonies to prison. Any reason not to proceed to sentencing at this time?
No, we would ask to proceed to sentencing, Your Honor.
Go ahead. You may address the court first.
Yes, Your Honor. I guess just for some housekeeping, we would object to Reagan-Tokes just because it's in the Supreme Court, just for the record's sake. This is what Ms. Naroda had put on the record is accurate. What is not on the record is that Ms. Brothers and Mr. Burns have a relationship. They have continued this relationship, and in fact, it proceeded on the 19th. It continued on the 20th. What happened on the 20th after this incident is that Mr. Burns and Ms. Brothers were together again. They called each other and they spent the night together. So I'd ask the court to take that into consideration as far as a determination as what an appropriate sentence is. We'd ask the court to adopt the recommendation of both the state and Mr. Burns. I think that the sentence is a reasonable sentence considering the principles and purposes of sentencing under 2929, as well as the fact that Ms. Burns suffered no injury to it. I guess there was a slight scratch on her leg from some glass, but there was no serious injury. There's no real physical harm. As I said, Ms. Brothers contacted Mr. Burns, and they wanted to spend the night together. So I think that that's important to recognize when you fashion the sentence, that the statutory scheme for a felonious assault was a range between 2 and 8 years. I'd submit that a 8-year sentence is typically on a first offense would be for if there was some serious physical injury. Understand Mr. Burns has a prior record, and that's why we've agreed to the 8-year sentence, the maximum sentence, as well as the repeat violent offender specification. So based on all that, I submit to the court that a 14-year sentence is sufficient to protect the public, as well as punish Mr. Burns, as well as to give to the community that Mr. Burns will be incapacitated for a period of time. That I think anything beyond that 14-year base level offense, aside from the Reagan-Tokes issues, would be too much. And so I'd ask the court to follow the recommendation of the state and myself and impose the 14 to 18-year sentence upon Mr. Burns, Your Honor.
Darnell Burns, do you have anything to say before I sentence you?
Your Honor, I just want to tell Jessica and her mother that I apologize, and I am remorseful for the situation that took place, and also to the courts, I apologize.
All right, let me hear from the state. By the way, what's the jail time credit? That should be
160 days.
160?
Yes, sir.
All right, go ahead.
As discussed in chambers with both court and defense counsel, the state is joining in the request for the 14 to 18-year sentence. The way the state arrived at that number and discussed it with defense counsel is that the defendant would receive a sentence on the underlying felonious assault of 8 to 12 years, 3 years on the gun spec, 2 years on the RVO specification, and 1 year as to the weapons under disability charge. And the court was made aware in chambers that the state has taken into account all the facts surrounding this case as well as the defendant's record.
Does the state have the firearm?
No, Judge.
Okay. So there's no contraband or instrumentalities?
No, sir.
But 160 on the credit?
Yes, sir.
Okay. I've considered the record, the oral statements made, the victim impact, the... Okay. Forgot to mention that to me. All right. Any objection to that? I mean, the effect of it would be that she can visit him in prison.
Yes, I believe they visit and speak now, so.
Pardon?
They visit and speak now, so.
Okay. All right. That's all you want to say? Okay. I've considered the record, the oral statements made, victim impacts, the court's history with the defendant, my conference in chambers with both attorneys, and a statement of the defendant and the defense counsel. I've also considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendation of the parties for an agreed sentence. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in divisions B through E of Revised Code Section 2929.12. In that regard, are factors that make the offense of felonious assault more serious. The victim suffered serious psychological harm, and the relationship with the victim facilitated the offense. And I'm sure that the victim felt an element of betrayal. There are no factors making the offense less serious, except that to whatever extent she would claim that she induced or facilitated the offense. In terms of recidivism, the court finds that there are factors making recidivism likely. The offense was committed while on post-release control. The defendant has a previous criminal history with crimes of violence for which I sentenced the defendant. There's been a rehabilitation failure after previous convictions, a failure to respond to parole or post-release control. In terms of making recidivism less likely, the offender exhibits a certain amount of remorse. The court determines that prison is mandatory on the firearm specification, that there is a presumption for prison on the felonious assault. The presumption cannot be overridden. The court determines prison is needed to protect the public from future crime. A minimum sentence would demean the seriousness of this offender's conduct. The court determines that the firearm specification time must be consecutive. Any repeat violent offender time must be consecutive. Other than that, the court determines consecutive sentences are necessary to protect the public and punish the offender are not disproportionate to his conduct and the danger he poses, and that the crimes were committed while on post-release control. The harm is so great or unusual that a single term would not adequately reflect the seriousness of the conduct, and the offender's criminal history shows that consecutive terms are needed to protect the public. Moreover, it is the agreed sentence proffered by the parties. The court determines that the joint recommendation is appropriate, and that the court will adopt it and make it an agreed sentence. So on count 2, the RVO would be 2 years. On count 2, the gun spec would be 3 years. On count 2, felonious assault, felony of the second degree, an indefinite minimum term of 8 years, a maximum Senate Bill 201 term of 12 years, and a definite term on count 3, the weapons under disability, of 12 months or 1 year, all consecutive for a stated aggregate minimum of 14 years and an aggregate maximum of 18 years, including all specifications. The no contact order is terminated. The credit is 160 days. I am not imposing PRC violation time. I'll leave that up to the Department of Rehabilitation and Correction and the Ohio Adult Parole Authority. Court is not ordering restitution because nothing has been requested. Defendants to pay the cost of confinement, prosecution, supervision, treatment, and court costs. Count 1 is dismissed. Post-release control is mandatory for a minimum of 18 months up to a maximum of 3 years. I already told you the consequences for violation a few minutes ago. I explained the 8% credit, the 5 to 15 earned credit a few minutes ago. I explained the presumptive and maximum release date. I explained eligibility for judicial release. State block on the motor vehicle registration, firearms disabilities, bond if any is released, and no judicial release is possible during the mandatory prison time. Anything further from the state? Vince?
Nothing from Mr. Burns, Your Honor. Thank you.
All right, good luck.
Thank you,
We're
Your Honor.
adjourned.
All rise.
Oh, who's yours?
Yeah, this way.
You know, I'll come to you.
We're good, yeah. Next, this is the document, this is the indictment. So this is the count. You're pleading to, these are the two that she's going to dismiss after she comes through. And this, you have to go through this too, but yeah. And then we'll sign it when we said it's the right time to sign it. The only thing is, you talk kind of soft, so it is being recorded. And he's
Right.
way up there, so just make sure he can hear you.
Yeah, I had to move the mic
Yeah.
right in front of me before.
Yeah, because you're soft-spoken.
Yeah. Did you read that? Did you read that?
I did, and I have it in here. It's looking good. I think we're on a good track. Let me give it back to you, so I don't
Yeah,
forget.
that was the last, that's what I've been doing the last 8 years.
No, I like
I
it.
remember.
All improvements and everything that you have going on.
Yeah. Situation.
I have it in my newspapers. I need something else too. I need to finish that one. I don't know if I have responsibility and something else.
Maybe I don't have anyone. That's the one before that. Spelling. And I see you're gonna finish. Are you done with it? I didn't hear you this morning.
We have more time to work on it.
Yeah,
That's for sentencing.
Yeah, but this was this morning.
But when you finally do get it done, you address it to the judge, but send it over to me. I'll come over and get it. We can go through it. We'll talk about it in person after you're done. And then I take them over to court application.
Yeah, I was sending everything through the clerk before.
Yeah, I'll help with that. Some letters from your employer, or your employer that you're
I
registered.
don't
Or you talk to your family. They'll go to, they'll be written to the judge, but they go through. Yeah, it's easier too. Then I can run everything around.
You want me to remember your salary? I usually grandbabies. Holiday. There's something really mentioned in there. Like the Fairmont grandbabies too. 6 and 10. My mom. Yeah, it's a lot.
And her sister, right? Is her sister the same woman in alternate difference?
And man,
This is
she's
her-
sticking to the chair. I
your
built
mom?
it, no,
Her
I built a special apartment for it.
So we moved to the town.
Your mom's not in a wheelchair.
No, he was in the back. My aunt's definitely walker. So she had. Oh, those are the two that are suffering the most because they not had that all set up. Me and sliding to a Canada. You know. So I moved her in the house. How long after this do I get
We'll have to find out from the judge. You have to do a pre-sentence report and drug and alcohol evaluation. And then give us a date.
we're about the misdemeanors?
And then once I get the date, she'll tell the judge over there. There's something set in December on that case, right?
No, that's this case.
Oh, okay.
This
Oh, yeah.
case said
That was set for the
December
jury trial.
27th.
Well, Nicole, I told Nicole to tell her after the day what's going on.
That's good. I can't stay sheriff's department pushing anything more on.
You probably just wait for the sentence. Anything about the issue here, I'm missing that quick with her.
Right.
Oh, if you were with him, if that happened, they didn't know that.
Yeah. Right.
Did you live in Cuyahoga County somewhere?
I renovated houses, so I didn't have a permanent address. My address was always out here in Cuyahoga County.
All right, but you would be in Cuyahoga a lot for a while, years ago?
Yeah, I didn't buy a house, but I would move into the home.
Okay.
And first thing I would do is secure the doors, and nobody else could get in. I would set up my shoppers and do the storage, and then open it back up to the owner. And then have his people do the cosmetics, painting, drywall, and full life function. And just restore back the home machine, mechanical setup, electrical plumbing, heating.
It'll take a few months or longer for each one.
Depends on how the home is. When you couple of them, I appraise homes. So I go and tell them to see if they buy it or not. So I worked all over for stayed in Collingwood for 2 years. I was changing for a while. 50 years, I'm gone. Fuck that. That that. I go into some pretty bad areas. Nobody else does it.
So you work within Cuyahoga, Lake, Geauga, working the other times,
Yeah, I go all the way out to Conneaut, I have customers in Conneaut.
nothing to deal with.
Yeah, I do actually do it. Conneaut, Summit, Aurora, Forest Lake, Chaga, Cuyahoga. And there's 7 counties altogether.
Northwestern Ohio.
Yeah. I have distributors throughout the United States, just so another state. I can get all my materials delivered in the state of Montana, in the United States. Certified through all industry, including EPA and environmental inspection, waste hazards, fire suppression, rescue, rescue, and all that. residential, commercial, either way. Next will be rehab. Start with the rehab.
And that's possible.
Yeah. Now still co-partnership with Metro State Parks. It's my landline max.
Cleveland Metro,
Cleveland Metro Parks, yeah.
that's what you're saying about.
Well, my landlocks miles of it, about 15 kids to it. So I'm gonna sell part of it. With them in Houston. So they can get to their park property. I already got it for my property. It's not a problem. No, it's sick of it.
What'd you say about the Dutch today?
He come over.
Oh.
He doesn't. He's part of the land.
All rise. This Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. On record, this is case number 22, CR 000832, State of Ohio versus Danny L. Denley. Mr. Denley is in court, represented by counsel. Public Defender Vanessa Clapp, representing the State of Ohio, is Assistant Prosecuting Attorney Gold. Mr. Denley, you are charged in a 3-count indictment filed by the Lake County Grand Jury on September 19th, 2022. Count 1, aggravated possession of drugs, felony 5. Count 2, aggravated possession of drugs, felony 5. And count 3, aggravated possession of drugs, felony 5. And there's a forfeiture specification attached to each for contraband and instrumentalities of the offense. It's my understanding that you have entered into an agreement with the state whereby the state would find acceptable, and you would be willing to provide your plea of guilty to count 1, aggravated possession of drugs, felony 5, and forfeit all contraband and instrumentalities mentioned in the indictment. Is that your understanding as to what you want to do here today?
Yes, sir.
Before I can accept your plea of guilty to this charge, I have to determine if you know and understand the rights you are giving up, consequences of a guilty plea, and that you are changing your plea to guilty of your own free will. How old are you?
55,
How far did you go in school?
all through high school.
Pardon?
11th grade. 11.
Okay. And do you have the ability to read, write, and understand the English language?
I have a rough time with the spelling in English.
Okay. But you understand the spoken English?
I understand.
All right. And as far as the written plea of guilty, your attorney went over that with you word for word?
Yes.
All right. Are you a U.S. citizen?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No, sir.
Have you taken any within the last 48 hours?
No, sir.
Have you ever been medicated, hospitalized, or treated for any mental illness in your life?
No, sir.
Have you received a copy of the indictment?
Yes, sir.
And did you read or have the charges read to you?
Yes.
Do you understand the charges?
Yes.
Did you discuss those charges with your attorney?
Yes.
Did your attorney answer all of your questions to your satisfaction about the charges?
Yes.
Do you agree that count 1 describes what you did here?
Yes.
And do you wish to plead guilty to count 1 and the forfeiture of all contraband and instrumentalities?
Yes, sir.
I've been handed a 4-page document called Written Plea of Guilty, and did you and your attorney go over this document word for word?
Yes.
And do you understand it?
Yes, sir.
And did you discuss this document with your attorney?
Yes, sir.
And did she answer all of your questions to your satisfaction about the document?
Yes.
Do you agree with what it says?
Yes, sir.
And do you wish to sign it?
Yes.
I'm going to go over the charge you are proposing to plead guilty to so that we are all on the same page. Count 1 says that on June 4th, 2022, in Lake County, Ohio, you knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. That's called aggravated possession of drugs. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11a, and it's a Division B offense when it comes to determining whether I should impose prison. Do you understand that charge?
Yes.
And is that the charge you wish to plead guilty to in this case?
Yes.
And then attached to it is a forfeiture specification that says that at the time of the offense, you had possession of or an interest in property which would be contraband or instrumentalities, and you would forfeit those on that basis, the items being all methamphetamine, a paper fold, a plastic container, and pipes. Do you understand that?
Yes, sir.
And do you wish to plead guilty to that?
Yes.
So you understand, if you plead guilty to the charge, you are admitting you committed the crime.
Yes, sir.
You understand, if you had any defenses to the charge, you give up those defenses by pleading guilty.
Yes, sir.
You understand that by pleading guilty, you are giving the court the power to sentence you immediately.
Yes, sir.
And you understand that any pending motions, I don't know when the case was set for trial, but if there's anything that's been filed in contemplation of the trial, I'll just summarily deny those to clean up the file, because once I accept your plea of guilty, the only thing remaining in the case to be done is to sentence you. You understand that?
Yes, sir.
and any rulings previously made by this court or any other court on this case would not be appealable because you're pleading guilty now.
Yes, sir.
You have certain trial rights. You're giving them all up by pleading guilty. I'm going to explain them to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights. As I explain your rights to you, if you have any question about what I'm saying or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Yes, sir.
You do not have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. That trial would be by a jury unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove you're guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal.
Yes.
You understand that with a jury trial, the jury makes the decision. I don't, whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. Do you understand that?
Yes.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of a particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes, sir.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. Do you understand that?
Yes, sir.
You have the right to tell your side of what occurred here and testify in your own defense. Or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty, have something to hide, maybe have a prior conviction. The jurors would be told you have the constitutional right not to take the stand and testify. We would select only individuals to serve as jurors in your case who answer under oath during jury selection, that they will uphold that right. Do you understand all of that?
Yes, sir.
Do you understand that if you were not pleading guilty today, you would always be represented by an attorney at law throughout this case, free of charge to you, paid for by the taxpayers?
Yes, sir.
Do you understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout the case? You could appeal the jury's verdict. You would have a free transcript typed up of everything that was said or done in this court, so you can demonstrate to a higher court any mistakes made here to get those mistakes corrected, and a free attorney to handle that appeal for you. Do you understand all of that?
Yes, sir.
You understand a plea of guilty is a complete admission of guilt.
Yes, sir.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to count 1, aggravated possession of drugs, felony 5, and the forfeiture specification as amended?
Yes, sir.
Are you now, or were you, at the time of this offense in June of this year, on parole, post-release control, community control, sanctions, or probation to any court anywhere?
No, sir.
Have you ever been to prison before?
Yes, sir.
How many times?
Twice.
And what year was the first time?
It was 04.
Did I send you to prison?
I think it was 14. Second time you did.
The second time I sent you to prison? Who sent you the first time?
Cuyahoga.
Oh, Cuyahoga, okay. And what was that conviction for the first time?
Possession.
And the second time?
Possession, cocaine.
All right. Do you have any other felony convictions on your record for which you were not sent to prison?
No.
So do you understand, by pleading guilty, you are voluntarily giving up your freedom for whatever length of time I sentence you to prison, jail, or community control?
Yes, sir.
And you understand that on this charge, I can send you to prison for 12 months. If I did send you to prison, 6 months would be the minimum, and it would be a whole number of months between 6 and 12, and I can fine you up to $2,500. You understand that?
Yes, sir.
You understand you would forfeit all of the contraband and instrumentalities mentioned in the indictment.
Yes, sir.
You understand that I can suspend your driver's license for 5 years.
Yes, sir.
You understand that while in prison, you may be eligible for, be offered, and be able to earn some credit against prison time to be served by engaging in educational, vocational, or rehabilitational programming offered to you for that purpose. The prison credit maximum is normally 8% of time to be served. You might be able to stretch that to 10% or a certain number of days according to their regulations. You understand that?
Yes, sir.
On your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. You give your rules, you violate their rules, they can return you to prison for up to 6 months in this case, even for one violation. All of that time is part of the sentence. And should the violation of PRC be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for another year. All of that time is already part of the sentence. Do you understand that?
Yes, sir.
If I chose not to send you to prison, I would place you on community control sanctions for a period that could last for up to 5 years.
Yes, sir.
Under the community control sentence, you'd have to abide by all probationary conditions that I would establish for you in the case, which would include time in a local jail, the fine of up to $2,500 I mentioned, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, any treatment I determine you need, substance abuse or mental health, community service, the license suspension up to 5 years, the forfeitures that I mentioned, a no-contact order, anything I determine you need to do. Do you understand? You would be required to perform exactly what I tell you to do, exactly how I tell you to do it.
Yes, sir.
If you fail to do so, you'd be brought back before me on a probation violation. I will conduct a hearing. If I determine that you did violate your community control sanction, I can extend the period of time that you're on community control for up to that 5-year maximum. I can increase the nature and severity of the other conditions under the community control, meaning more time in jail, more treatment, more things to do, or I can terminate community control altogether and just send you to prison for 12 months. Do you understand that?
Yes, sir.
You understand that, and this is more of a reminder, under Ohio and federal law, you are disqualified from purchasing, owning, possessing, or using firearms or ammunition for firearms.
Yes, sir.
There are other disqualifications that accompany a conviction. In this case, if you are sent to prison, you cannot vote from prison. You'd have to re-register to vote upon your release from prison in order to regain your ability to vote. You cannot serve as a juror while on community control or post-release control in any case where the state of Ohio is a party, because you would then still have an active case going with the state of Ohio as the other side, and you cannot hold any position of public honor or trust. Do you understand that?
Yes, sir.
You understand, in addition to the fines the fine and the forfeiture that I mentioned, I will order you to reimburse the government the cost of confinement, community supervision, any treatment, and court costs.
Yes, sir.
And do you understand the cost of confinement includes transportation costs between the court, the jail, and the prison?
Yes, sir.
You understand I will enter a judgment against you for the costs of prosecution.
Yes, sir.
If you fail to pay that judgment or timely make payments on a payment plan approved by the court, and you are serving a community control sentence rather than a prison sentence, you may be able to substitute community service to work it off. By local rule, you'd work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. Do you understand that?
Yes, sir.
You understand a failure to pay all fines and costs in full can result in the state blocking your motor vehicle license plates until they are paid in full.
Yes, sir.
Do you understand all the potential penalties?
Yes, sir.
Do you have any question at all as to what can happen to you as a result of your plea of guilty today?
No, sir.
Do you understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing?
Yes, sir.
And that when it does come time for sentencing, do you understand I'm not bound by and do not have to follow the recommendation of the prosecutor, your attorney, or even a joint recommendation as to the sentence?
Yes, sir.
And Ms. Gold, has the state of Ohio promised Mr. Denley anything in this case other than the plea charge?
No, Your Honor.
And did you hear and understand what the prosecutor just answered to my question?
Yes, sir.
And is that true? She hasn't promised you a recommendation specifically of anything, including probation or community control?
No.
Correct?
Yes, sir.
Has anyone else made any kind of promises or threats to you in order to get you to plead guilty?
No, sir.
Are you entering this plea freely and voluntarily?
Yes, sir.
Have you told your attorneys, and by your attorneys, I mean not only Ms. Clapp, but also Billy Kilmeyer, who also represented you on the case. So have you told your attorneys everything you consider important in this case?
I have told Vanessa.
Okay, you didn't hold back anything from her?
No.
Have you had enough time to discuss what you're doing in this case with your attorneys?
I feel adequate. Yes.
Right. Although this may be your attorney's recommendation for you to plead guilty to count 1 and the specification, is this your own decision and voluntary act to do so?
Yes, sir.
Have your attorneys done everything you've asked them to do for you in this case?
Yes, sir.
And are you completely satisfied with the legal representation you received in this case from the Public Defender's Office?
From Vanessa, yes, sir.
And Ms. Gold, basis for the recommendation, and what would the facts show if the case went to trial?
Thank you, Your Honor. The facts would show that on or about June 4th, 2022, in Painesville, Lake County, Ohio, officers conducted a traffic stop on the defendant and searched his person. In a pocket on the defendant's person in a paper fold, they located suspected methamphetamine. It was sent to the Lake County Crime Lab, where it tested positive for 0.51 grams of meth, a Schedule II controlled substance. And the other items from the forfeiture specifications, the glass pipe and container, was in the defendant's vehicle.
Mr. Denley, did you hear and understand everything the prosecutor just said?
Yes, sir.
And is everything she said true?
Yes, sir.
What is your plea to count 1, aggravated possession of drugs, felony 5?
Guilty, sir.
Your plea to the amended forfeiture specification for contraband and instrumentalities?
Guilty, sir.
I'm going to hand you the written plea of guilty document we talked about earlier. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do. I've made my markings on this document in red so you can easily tell what I've done to it since you and your attorney last saw it.
Thank you, sir.
Everything in all these forfeitures. And nothing else. I married it there. Here's another person. Your Honor, Mr. Denley has signed and dated the document, as have I.
Your Honor, I have signed this document as well. May I approach?
Yes. The court will sign judgment entry at the end of the written plea of guilty, and I will make it part of the record in the case. The record should reflect that defendant Danny L. Denley was here with public defender Vanessa Clapp in open court. I informed the defendant of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I also find Mr. Denley understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his plea and find him guilty of count 1, aggravated possession of drugs, felony 5, revised code 2925.11a, and the amended forfeiture specification attached to it for contraband and instrumentalities. I'm going to refer you to the Lake County Adult Probation Department for a pre-sentence investigation and report and a drug and alcohol evaluation with a brief mental assessment. Any other purposes for referral?
No, Your Honor.
You still live at 12732 Concord Hamden Road
Yes, sir.
in Chardon?
Yes, sir.
And do you have a land phone line there?
Yes, sir.
And what is that number?
440-352-1939.
1939.
Yes, the other number, 352, is a business number as well.
That's the 2139?
That
Okay.
does no longer exist.
All right.
Yes.
Now, you have a Chardon address, but a 352 number. That's a Painesville number.
The property lies right on the line.
Okay.
And both numbers are actually a business number for heating and air conditioning.
Okay. Sentencing is set for Monday, January 23rd, 2023 at 10 o'clock a.m. And what's the bond set at?
25,000 cash sureties.
And what was it set so high?
So, Your Honor, in municipal court, it was set at $50,000 cash surety, 10%. We had an in-court arraignment because defense counsel was asking for an OR bond, and the state opposed, and we had a court arraignment with Judge Condon as the arraigning judge. The state opposed an OR bond and laid out the defendant does have a long history of failure to appear, including a failure to appear in this case, and I opposed the OR bond and said that the state would be amenable to a lower cash bond, and that was the number that Judge Condon deemed appropriate.
I don't have any history.
Okay. So what's his credit?
Yes, I know.
As of now, he's been in jail since.
August 7th. A2.
Since August 2nd.
Okay. But you have a long history of drug abuse?
I had this last 8 years I've been clean, 6, and been concentrating on the church, taking care of my family.
Okay. Well, the only time that I will have left is two choices, jail treatment program or prison. Because any further treatment in a lockdown facility won't be able to be accommodated. And I don't have an earlier sentencing date, and the probation department, including Dr. Rinsberg, needs a certain minimum time to do their evaluations. So I'm sorry about that.
I have already talked to my old counselor in Lake Chaga recovery programs right here in Painesville, which she helped me last time stay clean for these many years now.
Okay, well, then you work with your counsel between now and the time of sentencing to propose a program that I would go with rather than a prison term or something that I would run out of time, but I'm not going to change the bond based upon what the prosecutor said, your failure to appear, not only in this case, but a long history of failures to appear.
I don't understand the long history of failure. I have not seen that or remember that.
So he did not appear here when?
That I know.
You do know that?
Yeah.
In
What about?
municipal court during the pendency of this case, he failed to appear. In 2018, the defendant was convicted of an F5 possession in Cuyahoga, and during that case, he failed to appear to his arraignment. Also in 2018, the defendant had a case in Cuyahoga that resolved as a M1 attempted possession. He failed to appear to his arraignment in that case. In 2005, the defendant had an F5 possession case in Cuyahoga, and he had KPSs for probation violations in that case, and in 2004. So those are the failure to appears that the defendant has had recently.
Yeah. The failure to appear is because I was in court in the same building, and they had both court days on different levels of the building for the charges.
You're talking about downtown?
Yeah. Yeah.
Okay, but that only answers one of them.
Yeah, I asked for this history report. I wish I would have seen this.
All right.
Because
But the bond was adjusted by Judge Condon, $25,000 cash surety, 10%?
Yes, Your Honor, at our in-court arraignment on September 22nd.
All right, I'm continuing bond at that. Is there anything further? The probation department will talk to you over at the jail. I'm printing out the referral. Anything further from the state?
Nothing further, Your Honor.
Fence?
Nothing, Your Honor.
All right, we're adjourned.
Thank you, Your Honor.
Yeah.
I wrote the clerk, I wrote everybody in the history.
Oh, I have.
Because I knew there was discrepancies between.
That's next week. I'll come over, I'll bring over. I looked at it this morning, so tomorrow. I'm going to discover everything.
All right, so we can do this one.
See you later
Thank you.
this week, okay?